We rocking, dog. We rocking and we moving. We rocking and there's no games. No games being played. No more games being played with these white people. We going to court. It's time to start suing these motherfuckers for everything they got every time they do something. That channel was for the people. You done took all of this knowledge out the people mouth. How you gonna do the people like that? How y'all doing the people like that? Huh? Y'all gonna do just do the people like that? We see you bitches in court. This will be added to the lawsuit, and I need my bag. I need my bag. You may very well be witnessing the end of an empire. Because I'm not going to stop until I own YouTube ass.
What's going on, guys? It's your girl, Angie Snatch, coming at you with another episode of An Unbiased Truth. Welcome back to the Snatch Gang, and welcome to all my new subscribers. So today we're going to talk about, we're going to take a deeper look at young Pharaoh's case against YouTube. So a lot of people reached out to me asking me, was it a scam? And I want to do a 5-day series going into actually what he's alleging in his YouTube case. Now, this case was filed prior to them deleting his channel. This case is more about 2 deleted videos. Young Pharaoh raised a total of $96,270 with over 3,000 supporters for this case. Now, I did a poll recently. It's about 5 days ago now that I did this poll asking you, do you think young Pharaoh should return the donations received for his YouTube lawsuit? 53% said yes, the case was dismissed. 8% said no, that money was spent on legal fees. 26% said I really don't care. And 13% said what YouTube case. So for that 13%, you're going to find out here with me in this 5-part series. For the 53%, I'm not sure if this money wasn't used for this case, and I'll show you why. Young Pharaoh is represented in this case by a woman named Chris Armenta. Chris Armenta, she is no fly-by-night attorney. She actually represented a Harvey Weinstein victim in a civil case against Harvey Weinstein. But on top of that, she has represented several conservative content creators who have had their channels deleted as well. Now, and I do think that young Pharaoh probably should have been honest, because Chris Armenta was probably honest with him. What she's trying to do, I think that she knew that this case would be dismissed, and you know this case is now being appealed. She's trying to put case law on the books, so she's pretty much gearing up for that appeal. That's what she wanted, in my opinion, from the beginning. If you go to her website, Armenta and Soul, they have a tab dedicated to censorship in modern America. And if you look right here, you'll see Daniels versus Alphabet, and who pops up? Young Pharaoh. Now, they do not have any updates as far as the appeal, but as you can see, Young Pharaoh is still listed on Chris Armenta's website. Now, Google in this case is going to be represented by Miss Lauren White. Lauren White, what she basically covers is Section 230 cases. And what Section 230 is, it is a rule that Congress passed, especially with all of the misinformation that was going on, that creates this oversight for social media companies with responsibility. So before, if you were a third-party creator, companies like YouTube or Facebook weren't responsible for your content. But under Section 230, now they have oversight. And if they deem content to be harmful or misleading, they now have the power to delete it to avoid them being caught up in lawsuits. So that's what Lauren White does. What we're going to do today, I want you guys to hear the actual transcript. I pulled the transcript from the court hearing last October, where Chris Armenta is arguing exactly what young Pharaoh's defense is and what they're saying Google is doing. Now, what you will notice is he's arguing about 2 videos, and the premise of it is that YouTube, under the direction of Congress and Adam Schiff, in a concerted effort, deleted his YouTube videos. But on top of that, he's saying that they stole money from him because His subscribers super chatted during those videos, and they're alleging that they have affidavits from their subscribers that they never received refunds for those super chats, and young Pharaoh never received the money for those super chats because those videos were deleted, but YouTube then kept the money. The judge wasn't really buying the First Amendment claim, but he was open to that claim about the super chats and where is that money, or how much money young Pharaoh is saying that YouTube stole from him. So I want you to listen to this transcript and I'll come back on the other side.
Well, when they pass a law or when they issue a subpoena, there will be government action. But until then, there is no government action at issue in this case at all, and specifically, no government action as to your client's videos. So I think while you may view this as a test case, it doesn't seem like it's really likely. But I will not be persuaded that individual members of Congress speaking out publicly, even on their own letterhead, and in their capacity as members of Congress or heads of committees or whatever they're doing will count as government action in this context. So I don't think you could amend. So the key point here, and I think one that is probably worthy for you to address, is there any amendment that you can make to your pleadings? And I'm not just thinking about casting it as a Bivens claim as opposed to a 1983 claim, but is there any amendment that you can make to your pleadings that would change the analysis?
Well, Your Honor, I'm not optimistic of our ability to change your mind on this point, but I'm cautiously optimistic of the ability to make a record. And that's really what I like to do at this point, if I may.
Okay, but my question is more pointed, which is I read your briefs. You have your arguments in your papers. I am not persuaded by the arguments in your papers. So the question for the court is whether I should give you leave to amend on that point.
Well,
And I don't see anything in the papers that suggests there will be any additional factual allegations that you could add, even if I were to permit you to cast the complaint as a Bivens action and not a 1983 action. So I considered that. Is there any other factual allegation that you could include in an amended pleading that would support, beyond what you already have, the claim that there is, that the defendants are state actors?
okay. I think, and I'm sure the court will have a view on whether this will be sufficient. But were we to amend the complaint, and I understand the court may well not view these items as sufficient to get past the state action element, but the kinds of things that we would be looking at would be the interactions between members of Congress, in this case, Schiff and Pelosi, and perhaps others, with respect to the threat of creating legislation if Google and YouTube did not go along with the censorship that they specifically requested with respect to the viewpoint of discrimination. So there are factual matters I think that we could discover, but of course, we have to get past the motion to dismiss stage to do that. And I think that the question of the level of coercion, the amount of encouragement, and the amount of really interference in big tech's business is a factual question as to whether or not it is enough to get to the one of the prongs of the Bloom versus Yardsky case that the Supreme Court re-articulated in Halleck. So this case is different than every other case that has alleged state action in big tech, Your Honor, because the majority of those cases allege state action based on the public function case. We have not really seen any case law develop, so I'm going to disagree with Your Honor there on the issue of coercion and encouragement. There have been, of all the cases cited in all the briefs before Your Honor, there is no case that alleges coercion and encouragement and joint participation and partnership in the way that has been alleged in this case. And so I think there is a clear difference between the allegations in this case and the many authorities that were cited, considered, and analyzed with respect to reaching the courts. What will likely be the court's decision? And I don't think that in Bloom versus Uretsky, actually in Bloom versus Uretsky, the court did give us some insight into what it would do if the allegations were different. In that case, in 1972, which I believe was a 9-0 unanimous decision. The Supreme Court said that the plaintiff had not alleged that the decision to transfer patient was made at the behest of the government. And the Supreme Court said if that were alleged here, this would be a different case. And that was the case since 1972. We are alleging here that the government did, in fact, be it through formal law or regulation, make a specific request for content based discrimination.
Excuse me, Miss Armenta. You're not, that's the problem. You're pointing to two members of Congress. You are not pointing to the government. That's the real issue. That's the real problem with your theory is that until you get beyond two members of Congress, or even if you have more, it's not the number. It's that individual members of Congress acting in their official capacity are not the government.
Understood, Your Honor.
That's the problem.
I think I would point to the Biaggi case, where I believe it was a state legislator who called an employer and got upset because a member of the public had Facebooked that the legislator was out driving drunk in a government car. And the court there said that when that person, that legislator, acting in their official capacity, leaned on the employer to fire that employee, they were, in fact, acting as a state actor. And I don't think that there are any courts that have held exclusively that you must have a formal regulation or you must have a formal law in order to convert it into in a state action.
I think the cases, with due respect, I think the cases have said even with legislation and regulation, that is not necessarily enough. So I think you have a real uphill battle with that theory because you don't even have an action of the government. You have individual members of Congress. And even if you did have an action of the government, it would have to be so controlling that the effectively the government regulation or statutory provision was taking over what the private entity was doing. And essentially, they would have no choice but to act. I think that the law has developed in that way. It's a real uphill battle for that theory. But you have made your point. I have.
I have one more point to make, just very briefly, Your Honor.
All right.
I'm sorry. I recognize I may be testing your patience, and I'll take that social risk, I suppose, and professional risk. But I would say that with respect to the cases where there's regulation or laws, those are the cases where the courts have said when you have a law of general application, then you're not targeting someone specific. So that's not the kind of state action or compulsion that we're talking about. Like when you force someone to give their social security number over in order to become an employee and ask someone to give ID, they said that in those cases, where you're talking about general state regulation and laws. No, that's not the kind of state action we're talking about here. But you can have state action in the absence of government law regulation. Consider, two police officers knocking over your door in an unlawful entry. And if they don't do it, but they're standing behind your neighbor and they're forcing your neighbor to do it, that is, in fact, state action. There is no government regulation, but they have enough power and enough influence to make that happen. And that's my point.
Okay, let's move on to the state law claims. Okay, breach of contract. I feel that while this could potentially be your opportunity to salvage something here, the complaint as it currently stands does not clearly tell the court or the defendants what exactly is the contract that was breached. So I'd like to hear for you to help me out with that. If you think it's in your complaint, and if not, what would you do to amend that?
The breach of contract is contained in the fifth claim for relief.
Mm-hmm.
It considers that YouTube's terms of service to be the contract.
Okay.
It provides a link for the YouTube terms of service. Google has so graciously provided the court with the actual terms of service attached as, I believe, Exhibit 1 or 2 to Ms. White's declaration.
And you agree that that is, in fact, the contract. That you intend to refer to? Is that correct? I think there was a dispute or a question about which version. The one that's attached as Exhibit 1 is the current terms of service.
Right. They're saying Exhibit 1 is the current terms of service. Exhibit 2 are the prior terms of service according to what Google said. Let's go with what they say. And I think that's fair. In Exhibit 2, the terms of service that existed prior to the blocking of the content that's at issue here, those terms of service, which Google drafted and its users agreed to be bound on, said that YouTube reserves the right to decide whether these content violates the twos, and they also said that they can, without prior notice and in its sole discretion, remove the content or terminate the account. But looking at the operative one now, which we link to in our complaint at paragraph 85 in the fifth clause of action, in this one it says YouTube actually changed their terms of service and they imposed on themselves some different standards for removal of content. On page 5 of 7 on docket 18 2, YouTube's term of service that are operative in this case and referred to specifically in the fifth clause of action say if we reasonably believe that any content is in breach of this agreement or may cause harm to YouTube, our users, or third parties, we may remove the content in our discretion. I think we argued in our papers and we pointed out that the reasonable belief language creates a limitation on what YouTube could do. Whereas prior, they had completely unfettered and unabounded discretion according to their own contract. Now, on a contract which they themselves drafted and wrote, and which must be interpreted against them according to the rules of ordinary construction, they have imposed this reasonable requirement. The second issue is
Wait, but let's just focus on that one. What's the breach?
so they removed it without a reasonable belief that the content would cause harm to YouTube or users or third parties.
Why do you say that?
Well, we have to allege that because, frankly, we still are uninformed as to why YouTube took it down. And that actually leads us to the other issue, which is alleged throughout the complaint that YouTube never provided notification to young Pharaoh of why they were removing his content. They simply did so without notifying him. And I will point out that in Google's papers, they claim, oh, we admit we told them. But no, what the complaint says is that when someone navigates to the link itself says this has been removed for such reason. But they never notified young Pharaoh of what it was removed, of why it was removed. And that's a problem that is pervasive, apparently now, not with respect to young Pharaoh. If you look through the rest of the terms of service that are incorporated in Exhibit 1, they have the community guidelines, the cyber harassment provisions, the hate speech policies. Every single one of those says, and I quote, if your content violates this policy, we will remove the content and send you an email to let you know. If you look through young Pharaoh's complaint, they never let young Pharaoh know that they had removed his content. They never sent him an email letting him know, breaching their own notification procedures that they imposed on themselves. In fact, that's one of the themes that's in the complaint. He only finds out after the George Floyd video hit 1 million views. It suddenly gets taken down, and he doesn't even know it gets taken off until he starts to get social media engagement from his viewers.
So, is the plaintiff's argument then that the breach is the failure to notify, not the removal of the video itself?
No,
Or both?
it's both. And I think if we look at the fifth claim for relief, there is number one is they failed to inform him, which would be a violation of the policies, their own policies that I just read, which are linked in paragraph 85. Number two, provide an appeals process. They say, and we could go over those terms as well. They say they're going to provide an appeals process, but our view is that the appeals process that they provided was not consistent with what they represented they were going to provide and they contracted to provide. Their appeals process consisted of no notification, Mr. Daniels engaging with them, and them terminating the chat when he continued to ask why his content was removed. Number three, permit the posting of the videos unless they violated YouTube's community guidelines. So there, we're going to the heart of removal, Your Honor. Their responsibility has to leave it up unless they reasonably believed it violated the community guidelines. Number three, they breached the contract by failing to permit the continued posting of the content. And number four is, of course, the terms of service that arise out of the YouTube partner program, where YouTube has promised, and they use words in their terms of service that say shall pay. So
And what did they not pay that they were supposed to pay?
So, in a live stream, when Young Pharaoh was live streaming, and donors, so members of the public, can click on a button, and it will, like if you're watching a video, it's being live streamed. And I just want to explain this if the court hasn't been in a live stream of this kind. You can, if you have a channel and you're a YouTube partner, you can engage in what's called a live stream. And that means that a user who's watching it can click on a button and say, donate $5, donate $10, donate $20. And the agreement with YouTube's in the term of service that YouTube, the defendants here, have provided the court say that they will and they shall provide a split of those monies with the content creator. It normally ends up being around 70% of those donations that the content creator gets. And what we allege is, in the case of these videos where consumers gave money to YouTube, handed it through YouTube to their portal, and YouTube then erased, demonetized, blocked, removed, whatever you want to call it, their videos, YouTube actually kept the money, and they.
Do you know that for sure? Do you know that donations were made and were kept?
Yes, I do, Your Honor. I have declarations.
Where is that alleged in the complaint?
Sure.
All I see is allegations about statistics, not about the particular videos and donations made on a live stream of any particular video.
Let me find it, Your Honor. Okay. Let's look at paragraph. Oh, here it is. Okay. So if we look at paragraph 13, Your Honor,
Uh-huh.
at paragraph 13, it says that YouTube has also retained monies that Mr. Daniels, fans, and followers have donated to him through YouTube's platform super chat functions.
Okay. What amount of money was retained by Google from that particular? I don't know if it was both videos or just one. But how much money was retained by Google that should have, per your contract allegations, been provided to Mr. Daniels?
I wish I knew, Your Honor, because we also allege in the complaint that when YouTube took down the content, removed the content, they also removed Mr. Daniels' ability to see the analytics. So that information as to the amount of money is solely in the possession and custody of YouTube. It's like if I steal a box of cash from you, Your Honor, you know there's money in there. I'm holding the box, but I won't let you look at it. And then I'm telling you, well, since you don't know how much is in there, you can't have a claim. It's the argument that Google has made on this is absurd. They're in the sole possession of the amount of monies that YouTube retain. I will tell the court, as a matter of ethics, we have, in fact, reached out, and some of Mr. Pharaoh's donors have provided us with sworn declarations under the penalty of perjury that they donated monies and that they never received them back, nor are aware that they went to young Pharaoh. Therefore, the logical inference is that YouTube retained them. Now, YouTube, in their defense, has claimed that they have not, but I have yet to see any documentation of that, although we have requested it.
All right, so Ms. Armenta, if I permitted you to amend your breach of contract claim to identify the specific contract provisions that you believe were breached and to identify each of the elements, so specifically the harm that was alleged, the harm that was suffered by Mr. Daniel, you're telling me that you could do that. You can make those amendments if I felt that that was necessary to adequately state a breach of contract claim. Or it sounds like there may be multiple breaches that the plaintiff is alleging.
Yes. I mean, I I think we can make it more specific to the extent that the court wants more specificity on the breach of contract. We have alleged that they didn't inform the plaintiff, that they didn't provide the appeals process, that they didn't permit the video to stay up, and that they didn't pay the plaintiff. And we've actually linked to the specific terms of service at issue. But if you want us to spell it out with more specificity, I think we could certainly do that.
Okay. And you would be, but right now you're telling me that you're clear that it's the current terms of service that you're alleging are the ones that were breached.
Correct.
Okay.
Because the current terms of service have been in place since before the incidents at issue. So there hasn't been a shift.
Okay. No change in terms. Okay. So then the question that the defendants raised about your conversion, money had and received, and unjust enrichment claims, these are really based on your contract allegations. They're really not independent claims in any way. And so my first question is, how do you distinguish these claims from your breach of contract claim?
Well, first of all, I would say that it's certainly fair to plead theories in the alternative. So if the court or a jury ultimately decides that it's not fairly subsumed in the breach of contract and the contractual provisions with specificity, certainly a conversion claim would be brought to the extent that YouTube and Google grabbed that box full of cash and didn't give it over. So I think in the alternative is fair with respect to those state law claims. In addition, I think that they can coexist. It's really a matter of remedies and not duplicating the remedies. And I think that's something that would be sorted out at the conclusion of the case, not at the pleading stage.
But it does sound that you haven't, it seems to me that you have not pled, for whatever reason, the elements that you would need to plead, say, for example, for conversion, which does require pleading of a some certain.
Actually, I'm not sure that I agree with that. I think that what the case that Google cited said was that it has to be capable of being ascertained. So I don't think that anyone would agree that just because I took your box full of money and you can't now count it, that means that you don't have a conversion claim. So what the court said is you can't have sort of a willy-nilly broad conversion claim. But we've made it very specific. It's the specific money that people donated that YouTube retained and did not give to Marshall Daniels, whatever that amount may be. So it's very capable of being ascertained what that number is, be it by category, description, by temporal element. It's not just a sort of vague, soft issue.
It sounds like a breach of contract claim as it's currently pled, in all honesty. But I take your point that pleading an alternative may be appropriate. And if you don't have the information and based on the circumstances you can't get it, that may factor into at some point. Even if it's not adequately pled at this point, at some point, it may be capable of being pled. Let me ask you a question about your UCL claim. What is the basis for the UCL claim? Is it the First Amendment violations that are pled as their own independent claim? Is that the unlawful act that is the basis for the UCL claim?
Young Pharaoh's complaint against Alphabet Inc., Google, YouTube is a complaint for a violation of the free speech clause of the First Amendment of the United States Constitution, breach of the covenant of good faith and fair dealing, conversion, unjust enrichment, breach of contract, money had and received, violation of Section 17200 of the California Business and Professions Code, fraud in the inducement, and wire fraud. Now, he did demand for a jury trial and injunctive relief. That was what that argument was about, because the court was not so sure that you could make a claim for monies had and received if you did not have a sum of those monies. But what Young Pharaoh's attorney was arguing is that when they deleted the video, they deleted the analytics, the only person that has the possession or ability to give us that number are the defendants in this case. Now remember, this is part one. I just wanted us to be on the same page of what exactly young Pharaoh is saying that Google did to him. In part two, I want you to hear the defense from Google, because this was the motion to dismiss argument, in which, though we will go through the whole case because it's at appeal now, Google did get that motion for dismissal granted, so they never had to turn over those funds to young Pharaoh in any form, not as of yet. Now, I'm imagining that with this appeal going on, with their response, they're going to have to be a little more in depth in proving that they did not keep that money that young Pharaoh is alleging that Google kept from him. All right, guys, I'm going to rest for the weekend because I'm still sick. I feel better, but I'm still sick, so I'm going to rest for the weekend. Enjoy your weekend. It's your girl, Angie Snatch.